seeing him.
Good evening, sir. How are you?
Yeah, good evening. Good evening. So very nice of you and my other friends who joined this session. Let me greet all of you. And the subject of today is that OBCs and breaking 50% ceiling and the constitutional base for deepening the social justice organized by All India OBC Students Association, and who has taken, Mr. Kiran Kumar has taken the lead to organize such a discussions. It is nice of him. And on this topic, I would like to take certain, can I take some 25 minutes, 20-25 minutes? What? Any time restriction is there? Kiran?
Pardon me, sir? Pardon me?
Can I take 20 minutes or 25 minutes? Anything?
Yeah. You can take 15-20 minutes, then
Okay.
Followed by Ramesh sir.
Yeah. Okay, nice. Okay. So let me begin with that. Prior to independence and after independence also, few of the states has been implementing reservation for backward classes, scheduled castes and tribes. But at the union government level, even though provisions under Article 16(4) and subsequently by the first constitutional amendment inserting Article 15(4) were available, backward classes, who we are calling now as OBCs, other backward classes, were not provided reservation in union government, both in education and jobs. Article 340 clearly stipulates that appointment of a commission to investigate the conditions of the backward classes. So the president may by order appoint a commission consisting of such persons as he thinks fit to investigate the conditions of socially and educationally backward classes within the territory of India and the difficulties under which they labor, and to make recommendations as to the steps that should be taken by the union or any state to remove such difficulties and to improve their condition, and as to the grants that should be made for the purpose by the union or any state, and the conditions subject to which such grants should be made, and the order appointing such a commission shall define the procedure to be followed by the commission. A commission so appointed shall investigate the matters, refer to them, and present to the president a report setting out the facts as found by them and making such recommendations as they think proper. And the president shall cause a copy of the report so presented together with a memorandum explaining the action taken thereon to be laid before each house of the parliament. So there is a clear provision under Article 340 for Indian Constitution when it was introduced on 26 January 1950. The first Backward Classes Commission, headed by Kaka Kalilka, gave the report in 1955. But the chairperson, Kaka Kalilka, gave a separate note to the government stating that he is not in agreement with the recommendations of the other members, as altogether the recommendations are contained in the report. So there was no action taken on the report, it was completely shelved. Thereafter, only in 1979, when the Janta government came, the second Backward Classes Commission headed by BP Mandal was constituted, and Mandal, after touring various towns, cities and villages, gave the report in December 1980, but it was also not placed in the parliament immediately. Lot of action programs had to be conducted even for discussion in the parliament. Finally, after 10 years, when VP Singh as the Prime Minister of this country issued orders reserving 27% for OBCs in direct recruitment in government services. But the order was stayed by the Supreme Court, and the judgment came only in November 1992. So it took nearly 45 years to get approval from the highest court of this country that the backward classes who have been historically discriminated can have an affirmative action in the union government by an order of November 1992, and which was subsequently implemented through an office memorandum of 8th September 1993. But when the matter came before the court, the case before the court was about the orders issued by the union government, both by VP Singh and subsequently in 1991, when Narasimha Rao government came, they issued another order. Both were challenged. So the court, the case before the court was about those orders only. But the Honorable Supreme Court took upon themselves and discussed altogether the whole gambit of reservation policy and finally gave a judgment. They upheld the order issued by VP Singh government to provide 27% reservation in job, but with the riders. Number one, 50% ceiling. Number two, creamy layer. Number three, ban on reservation in promotion. So on 50% ceiling, reservation to backward classes, they have faced various hurdles caused by the dominant caste. One such as a hurdle is an attempt to fix a ceiling of 50% on the quantum of reservation. Nowhere does the Constitution prescribe a 50% ceiling on quota. Yet in 1962, the 5-judge bench of the Supreme Court in the M.R. Balaji versus State of Mysore case laid down that reservation should be less than 50%. However, in 1975, another 5-judge bench of the Supreme Court in the state of Kerala versus N.M. Thomas case, considering all the decisions relating to the 50% ceiling, concluded that the percentage of reservation would be incumbent on facts and circumstances of each case, and no hard and fast rule could be laid down. The quota matter cannot be reduced to a mathematical formula so as to be adhered in all cases uniformly. In fact, the Supreme Court gave an illustration that if a state government provides 80% reservation based on the population of backward classes in the state being 80%, the policy cannot be faulted with. As per the judgment, the dominant object of reservation is to take steps to make inadequate representation adequate for backward classes in public employment and education. Justice Rathanawal Pandian, in his separate judgment in the Indira Sani case, we call it as Mandal reservation case, mentioned about Ram Jethmalani, who articulated strongly that the observations in Balaji case, that reservation under Article 16(4) should not be beyond 50% is only an obiter dicta, since that question did not at all arise consideration in that case. So obiter dictum, a Latin phrase meaning that which is said in passing, an incidental statement. Such statements lack the force of precedent. So Justice Pandian further said, I see much force in the above submissions and hold that any reservation in excess of 50% for backward classes will not be violative of Article 14 and or Article 16 of the Constitution. So Justice O. Chinnappa Reddy, in Vasanta Kumar versus State of Karnataka case, reiterates his view taken in Karamchari in the following words. We must repeat here what we have said earlier, that there is no scientific statistical data or evidence of expert administrators who have made any study of the problem to support the opinion that reservation in excess of 50% may impair efficiency. At this point, I would like to remind the participants that Tamil Nadu, during Justice Party rule, which at that time we call it, it was called Madras Presidency, had communal GO, wherein there was 100% reservation to all communities, including the Brahmins. It has not affected the merit and efficiency of the Tamil Nadu state. So further, Justice Pandian observes by recalling the observation of Justice Hegde in Hiralal case, the extent of reservation to be made is primarily a matter for the state to decide. By this, we do not mean to say that the decision of the state is not open to judicial review. The length of the leave to be provided depends upon the gap to be covered. That is what Justice Pandian observed. But finally, the 9 judges bench of the Supreme Court in Indrasani case held that 50% ceiling should not be breached. So since the court observed, since this court has consistently held that reservation under Articles 15.4 and 16.4 should not exceed 50%, and the states of the union have by and large accepted this as correct, it should be held as constitutional prohibition, and any reservation beyond 50% would liable to be struck down, the judgment said. But the court never actually explained how or why it reached this 50% figure. For one, the number has no legislative backing whatsoever. No state or union legislature has proposed such a cap. Further, the cap bears little relation to the population that is covered under reservations, which far exceeds 50% number. In fact, Mandal also, in his report, has to restrict to 27% reservation to OBCs, citing the court judgment, despite the fact that the commission had estimated the OBC population around 52%. But on this point of 50% ceiling, the first to challenge this limit was the state of Tamil Nadu, with a strong political culture of backward caste politics. In 1993, the state assembly passed the Tamil Nadu backward classes, scheduled castes and scheduled tribes. Reservation of seats in educational institutions and appointments are posts in the services under the State Act to defy the Indrasani judgment and keep its reservation limit intact at 16%. The second, far more significant blow to the ceiling was struck by the union government itself in 2019 when it piloted a constitutional amendment through Parliament, which awarded a 10% quota in government jobs and education institutions to members of the upper caste on the basis of economic criteria, that is economically weaker sections. So now the 50% ceiling had an exception, not just in Tamil Nadu, but also nationally. However, at the same time, in May, the Supreme Court struck down reservations for Marathas in Maharashtra, citing amongst other factors the 50% ceiling. Hence, it is very much necessary that the union government brings a constitutional amendment to remove the ceiling on reservation so that the large sections of our society who have been historically discriminated and remain as socially and educationally backward classes can get their rightful and legitimate share in the governance of our country. Because today, what we are seeing is, by providing 27% to OBCs, despite the fact that the population of backward classes is around 60%, this 27% ceiling is the maximum. That is what the order has mentioned. So in what happens, in many of the state governments, if the reservation percentage for SC or ST is nearing 50%, whatever is left out is given to the OBCs, by which even this 27% is not available in many of the states in their appointments or education. So the ceiling of 50%, if it is removed, will pave way for the OBCs to get their legitimate and rightful share. That is what I want to emphasize on this occasion. The next one is the creamy layer. Creamy layer is an unconstitutional provision, and even the Constitution has not mentioned anywhere about creamy layer. And also Supreme Court, when they have imposed this creamy layer, despite the fact that the GO issued by the union government does not mention about creamy layer, till date, if we analyze the impact of this creamy layer, we can find that in the top echelons of the governance of this country, in the various education institutions, in the Group A, Group B post, the representation of OBC is not even 10% in many of the departments. Like for example, in the central staffing scheme, the secretary level post, 89 posts, there is 0 OBC in that department, in the secretary level. Even additional secretary level, the representation is 0. These are all the consequential effect of this unconstitutional provision of creamy layer. Simultaneously, an income ceiling is also imposed, wherein the salary income is included, thereby excluding the eligible candidates belonging to the parents working in the public sector undertakings and central government departments, which we have been taking up repeatedly with the government, but no solution has been given so far. So that is a major thing today that has to be addressed and attacked. And the third point, which I want to make it very important point, is that regarding the concessions relaxations, by an order of 1st July 1998, DOPT has mentioned that if any reserved category candidate, OBC, SC, ST, even if he gets the cutoff mark of the general category, if he has availed any relaxation, age relaxation or other relaxations, then he will not be counted against the vacancy of the general category. He will automatically be included only in the reserved category. This is a very dangerous provision that has affected our candidates. Despite the fact they got the cutoff of the general category, because of availing age relaxation, they have been pushed to reserved category, thereby affecting the OBC candidates who are able to get into the stream. They were all sent out of the reserved category provisions. So the Supreme Court in Jitendra Kumar Singh versus State of Uttar Pradesh has clearly said that if any person belonging to reserved categories is selected on the basis of merits in open competition along with the general category candidates, then he will not be adjusted towards the reserved category. That is, he shall be deemed to have been adjusted against the unreserved vacancies. It shall be immaterial that he has availed any facility or relaxation like relaxation age limit available to reserved category. Despite this Supreme Court judgment, the government has not taken any decision to withdraw that order of 1998. So that is a very important matter that has to be followed in the coming days to strengthen the cause of social justice. So all these factors which I have mentioned and the data that is available today in various government departments, in the various education institutions, for example, in 40 central universities, professors level, OBC 0, associate professors, OBC 0 out of 2,620 associate professors. That is the position. Even in the IIM or IIT, the representation is very, very negligible. That is 1% or 2%. Even in the group A or group B post, they have not even touched 15%. So these are all the important points that goes to prove that should be a reservation in promotion also. And the court also reason in the recent judgment of the 28th January 2022, Jarnal Singh and others has emphasized that collection of quantifiable data for determining the inadequacy of representation is a basic requirement for providing reservation and promotions as laid down by this court in Nagaraja case. The court was of the further opinion that the concepts of efficiency, backwardness, inadequacy of representation are required to be identified and measured on the basis of data. In case of a challenge made to reservations provided by the state government, it is incumbent on the state government to satisfy the court that the decision is supported by quantifiable data showing backwardness of the class in public employment, in addition to compliance with Article 335 of the Constitution of India. This judgment goes to prove that the need to have a caste census. That is why we have been demanding consistently that the government, union government, has to undertake the exercise of caste census along with caste census enumeration that has to be started by the government. Similarly, the recent judgment in the All India Court of Medical Seats case by the Supreme Court Honorable Judges Dr. G.Y. Chandrachud and A.S. Bopanna, upholding 27% reservation in the All India Court of Medical Seats, has made certain points very clear that Article 15.4 and Article 15.5 are nothing but a restatement of the guarantee of the right to equality stipulated in Article 15.1. Number two, binary of merit and reservation has now become superfluous once this court has recognized the principle of substantive equality as the mandate of Article 14 and as a facet of Articles 15.1 and 16.1. Number three, the individual difference may be a result of privilege, fortune, or circumstances, but it cannot be used to negate the role of reservation in remedying the structural disadvantage that certain groups suffer. So in the words of Justice Subbarao, it is the backward classes are centuries of calculated oppression and habitual submission that reduced a considerable section of our community to a life of serfdom. That is why this affirmative action is very much essential, and certain areas have to be taken up seriously in the coming days, for which our All India Federation has been consistently fighting with the government. And also we have now convened a meeting on 22nd May at Delhi, inviting all the major OBC associations of this country to form a joint action committee to pursue the matter in the coming days with the government in various forms of programs. Unless this is done, the concept of social justice will further be delayed. That is what I want to emphasize on this occasion and on this topic. I thank the opportunity given by the organizers.